So there's two things I'm going to start with in this presentation. In the first part, I want to briefly discuss workforce surveys conducted with anthropologists over the past 20 years. I want to discuss the surveys over the past 20 years because these give us an overview of changes and sentiments in the native title workspace and paint a picture of a field facing existential challenges. Secondly, I want to discuss some forms of claim resolution which are popular post-referendum and consider the ongoing importance of anthropology and its methods to ensure Indigenous land and sea rights. The question I ask is this: how do we reconcile a workforce under pressure and facing substantial hurdles, but which has significant potential to meaningfully pursue Indigenous rights and interests? And I don't seek to resolve these complex problems today, but rather to provide an overview of this workforce for a country in transition. My presentation begins with a broad overview of changes in anthropological employment in native title based on our 2023 survey. And when compared with earlier survey data, there's now growing concern from federal government agencies in the native title system about the future anthropological workforce, as Kevin has already indicated. So let's look at the surveys. In 2014, 2014, 2016 and 2023, sector-wide surveys were conducted to identify the number and features of anthropologists working in native title. The survey catchments included the Academy in 2004, and in 2016 further included anthropologists in land rights, and by 2023 the catchment extended to employees and disciplines allied to native title anthropology. The 2023 survey data tells us several things about the status and characteristics of native title anthropologists. The QR code there, if you take a picture of it, will take you to the particular spot on our CNTA website where you can actually see all that data. And I want to thank Honking Goff and Courtney Bowe for their assistance in the development of the slides. So, age and gender. One of the things, as you'll see, is we focused on that at one particular time. Would you go to the next slide, please? Qualifications and experience in the sector. I'm just going through these. They're available to you if you've taken the QR code. We'll go to the website. You can see there. This is a summary of what's been said in the survey. On expertise, next slide, please. I think one of the important things which leads to Kevin's talk is that we need some kind of support for transitioning into, say, the expertise category, the consultancy positions, and I'll come back to that in a minute. But one of the things that we predicted in 2004 was that there would be changes and increases in the people from mid-career moving into the expertise class, and that actually happened. Employment conditions. Next slide. Again, you can see some of the problems that were identified by people in the survey. Moral hazard being one of them. Should we be in this? Is it a colonial enterprise? Is it right for us to be doing this? And of course, the lack of career progression. Most of the structures that anthropologists work under in organisations are fairly flat. Pay and workforce, just the next slide. Surprising to some, workforce changes anticipated in 2004 and 2016 surveys have not materialised. We had anticipated mid-career staff and anthropologists would move into consultancy, replacing the older retiring cohort of consultants. Unexpectedly, many older practitioners, in line with the generalised profile of baby boomers, remain active in fieldwork and as expert witnesses. Too few mid-career staff anthropologists have opted for consultancy work, and clearly we need to acknowledge different strategies if we are to accommodate the diversity of employees already in our workplaces and those we want to attract. And at the time of the early surveys, we paid little attention to the characteristics of generational cohorts and their workforce aspirations. Next slide, please. When Chief Justice Mortimer cited research for anthropological evidence as one of the factors she argued was responsible for delays in native title cases, she may not have realised the extent of the workforce supply problem involved. And these are the figures about the work ahead which will require anthropologists, but they've been well canvassed by Kevin. While tertiary institutions now have limited appetite for teaching on native title law and anthropology, future training for applied researchers is likely to be on the job, a method surely attractive to time-poor NTRBs and service providers with restricted organisational resources. To support on-the-job training, so the CNTA website offers accessible, relevant content on anthropological issues. For example, next slide please. We have a range of articles under the tab compensation tab. And again, if you take a photo of that, the QR code will take you directly to that on the website. Other offerings are podcasts on such as Fundamentals in Native Title, and recently the full set of papers by the previous director of CNTA, Nick Peterson, each focus on a theme from the 11 conferences during his headship. Evidently, there are considerable challenges both within the discipline, including the tertiary sector, and from the wider society, all of which make the future of native title anthropology uncertain. I want to now turn to the role of anthropologists in broader political agendas post the failed referendum. This is an important position for exploring alternative ways to acknowledge rights, some of which paradoxically are outside the native title frameworks. Many were dismayed by the outcome of the October 2023 dual referendum questions, a mix of one question seeking approval to acknowledge First Nations in the Constitution with another question on an advisory instrument, Parliament. In the context of the failure of the voice, native title anthropology is one of the best opportunities to advocate for the voices of Indigenous Australians and to ensure their views and needs are meaningfully pursued, as well as enshrined in law. Working with the Native Title Act will become increasingly important as state-based treaties are favoured, including over statutory regimes. I suggest we recognise what is often overlooked, the achievement of Indigenous title to country through statutory regimes. And I believe that you, as native title anthropologists, are playing a pivotal role in statutory processes to advance Indigenous rights in country. Statutory land rights in the Northern Territory and the National Native Title Act have not only increased the Indigenous estate, but established a rights-based agenda based on free, prior and informed consent as a working principle in negotiations. As a result of the beneficial legislation, you saw the data that was put up, but 60% or more of the continent is now recognised as having Aboriginal rights derived from prior occupation, and over 25% of the continent has passed into Aboriginal control as Aboriginal freehold, and at least another 25 is recognised as carrying native title rights. Through the Future Act processes and Indigenous land use agreements, Indigenous Australians now have a legitimate and recognised seat at the table when negotiating for benefits with intergenerational impact. You are amongst those, alongside lawyers, cultural heritage researchers and community development practitioners, who consistently assisted Indigenous Australians in substantive and significant ways to gain recognition for Indigenous legal rights and formal acknowledgement of deep Indigenous connections to country and seascapes. In many cases, these achievements were won despite historical and legal denial from the wider community. However, models outside of statutory regimes for inclusion and broad-scale resolution of land interests are now emerging. Some see treaty, for instance, as an alternative to native title, and in a post-referendum climate, some state governments are chary, given the election responses, and are retreating from their previous enthusiasm for treaty. This is true in Queensland, for example. Nevertheless, Victoria, the NT and ACT continue to explore how treaty might be conceptualised, although interpreting this differently in each jurisdiction. In terms of content and parties to a treaty, however, there are several emerging questions. The first one is, what content might a treaty encompass, and between whom? Aboriginal people's expectations and what governments can deliver on remains unclear. The Indigenous party might anticipate global claims under a treaty, perhaps a suite of service delivery programs mirroring equality with a wider society, or an undefined political concept of sovereignty. The latter would surely open a set of highly complex and contested issues. How comprehensive or restrictive would a treaty be in terms of the Indigenous parties? Would treaty occur between one First Nations group and a state government, or would benefits flow to a cluster of regionally affiliated First Nations groups? Further, given different levels of specific government responsibilities, how might benefits, including possible compensation, be packaged? A further question: what instruments would bind the parties, and can provisions within the NTA play a role? A settlement of land and related issues concerned with the Southwest Native Title Settlement 2016 Belungas is in an act of the West Australian Parliament, and Professor George Williamson called it the first treaty. But have we moved to a treaty too quickly before exploring the extent of the Native Title Act, since the West Australian Government also created an alternative settlement under the NTA with the Yamatji Nation Indigenous Land Use Agreement in 2020? Both the Noongar and the Yamatji Alternative Settlement offer wide-ranging benefits, from recognition and economic development programs to heritage agreements, including a land estate, conservation estate, and a partnership arrangements. The Yamatji settlement incorporates the TVCs from determined claims within the designated fields, offering the additional advantage of resolving claim overlaps. Potentially more could be made of Inuas, since they offer at least three critical advantages. So I'm moving back to saying, under the Native Title Act, there are things that we may not have been using as much as we could. First, an Inuit can be used for any purpose. It could cover distribution of income payments, educational opportunities, and socio-economic goals. Secondly, it can bind intergenerational Indigenous parties and include a specific time frame for review of the contractual arrangements by successive generations. And third, with the contractual format, Inuas enable Indigenous people to advance their own priorities and processes for desired outcomes. Ultimately, expansive regional settlement models may offer benefits at local and regional levels through land use and management options to symbolic forms of recognition associated with local histories. However, the relationship between treaty and native title determinations aren't necessarily straightforward, and anthropologists in Victoria, where the structure for a treaty process is most advanced of all states and territories, have questions about differences in evidentiary thresholds between that for native title and that accepted for a treaty. Next slide. As O'Kane and Bogue discuss in their paper on the NTA website, fundamental issues are yet to be resolved, such as the definition of a traditional owner. And again, that will take it straight to the paper. Native title determinations may also forge new, if controversial, ways to achieve regional outcomes around landed interests. For instance, in the jury determination of 2019, the two overlapping claims were found to have two distinct societies each with their own laws and customs. And in the overlapped area, there would be two PBCs who would have to negotiate how they jointly managed landed interests in the intersection. In a further illustration of a regional settlement, the Federal Court in 2021 confirmed native title over sea country in the Torres Strait, while bringing together Aboriginal and Torres Strait Islander Australians for joint native title outcomes. I want to turn, in my conclusion, the move towards that, an anthropological question on identity about regional solutions. Over the past 30 years, native title claims have ignited recognition of local group identity, recognising clan names, cultural sites, and places of historical significance. Native title research has led to language revival and, in some cases, revitalisation of cultural practices and knowledge. Despite the term First Nations, Indigenous identity is grounded in localism and expressed through what Sutton termed families of polity, re-networked groups of kin linked to specific areas of country or sea, supported by performative, demonstrated knowledge of country and cultural mores. Localism, with its emphasis on specificity of place and people, may raise unexpected obstacles to broad territorial treaties, depending on how arrangements marry local affiliations with regional perspectives. Claims research focuses on small landed units as the enduring social and landowning units from sovereignty onwards. However, on a regional scale, a boundary dispute can arise between local neighbouring groups or raise membership challenges as expansion of local group membership occurs. So let me summarise. I'm sorry my readings have been a bit halted, but I'm finding it difficult to read with these glasses. In summary, the surveys give insight into past and present trends in native title anthropology, including its many challenges. Nevertheless, post-referendum Australia also presents opportunities for anthropologists to assist Indigenous Australians to pursue their cultural and legal rights. Whatever changes in structures and processes occur, anthropologists will remain essential players, contributing to the capacity of First Nations to speak about their connection and history, rights and interests in land, water and sea. The challenge for our sector is to think about how to support native title anthropologists so they can continue to meaningfully contribute. Next slide, please. Finally, I want to end with Bruce Martin's perceptive words about the imperatives to hear Aboriginal voices and act upon them. Many of you know that we lost Bruce last year, but he presented at two of the CNTA annual conferences in 2016 and 20, and he brought a lateral approach to how governments address issues confronting Aboriginal people.
I say to the blackfellas, the process is just as, if not more important than the outcome. And that comes back to the ownership. When people genuinely feel that they have ownership of the process, they'll be included, that is where people feel empowered and therefore take ownership of the outcome. I think that's one of the really big gaps in Indigenous affairs, is finding systems, structures, because that's what bureaucracy is about, but systems and structure that allow that process to occur. The inclusion of Indigenous people in planning and in process. You can have a fantastic policy. You can have the best policy in the world on paper. If there isn't the ownership, it's not even going to be worth the paper that it's written on. That's the reality.
Thank you.